Sweetie, Assistant Professor of School of Legal Studies and Research, is standing in front of you to head you towards the most important segment of today's program. Yes, you guessed it right. We are about to start the very important first session of today's program, which will be dealing with the Bharatiya Nyaya Sanhita 2023, for which we have with us Dr. Anand Deshmukh sir. Sir is Professor and Head at Department of PG Studies in Law, Dr. Babasaheb Ambedkar, Marathwada University, Chhatrapati Sambhajinagar. Sir's specialization are criminal and corporate law. Sir is in charge law officer at Dr. Babasaheb Ambedkar, Marathwada University, Chhatrapati Sambhajinagar. Sir was a former director at National Service Scheme NSS at Dr. Babasaheb Ambedkar, Marathwada University, Chhatrapati Sambhajinagar. Sir was a former director of Chhatrapati Shivaji Maharaj Study Center at Dr. Babasaheb Ambedkar, Marathwada University. Sir was also been a coordinator of Indian Constitutional Law. Sir has been a member of Board of Studies, Dr. Babasaheb Ambedkar, Marathwada University, and also of SP Pune University. Sir has completed his LLB from MP Law College, Aurangabad in the year 2000, and has completed his Masters at Department of Law, Pune University in the year 2002. So, has participated in various state, national and international seminars, conferences and workshops in different capacities such as paper presenter, resource person and organizer. He has published articles in various journals including national and international journals. Sir has worked on various committees and discharged various responsibilities assigned by the university. He has worked as in charge of Earn and Learn scheme for 6 years, and this scheme were highly appreciated by NAC peer review team. Sir has also worked as chairperson and member of local inspection committee for various colleges. Sir has worked as a member of grading committee and has worked as a director at Central Assessment Program, Dr. Babasaheb Ambedkar, Marathwada University. Sir has been a panel member of Mahalok Adalat organized by District Legal Services Authority, Chhatrapati Sambhajinagar. Now, I would request Dr. Syed Ahmeddin sir to felicitate Dr. Anand Deshmukh sir. Thank you so much, sir. We are glad and honored to have you, sir. So, without a further ado, I would like to call upon Dr. Anand Deshmukh sir to enlighten us about Bharatiya Nyaya Sanhita 2023.
Thank you, ma'am. Very good afternoon, one and all. First, I like to congratulate this School of Legal Studies and Research for organizing such one-day symposium on exploring the criminal law and media, a focus on three criminal laws. I think this inauguration is done with the auspicious hands of Advocate V.D. Sarangi, who was the former chairperson of Maharashtra and Goa Bar Council. So the today's topic given to me is to speak something about the Bharatiya Nyaya Sanhita. Initially, it was the IPC, that is the Indian Penal Code. So I like to ask the students, how many students studied this IPC or Bharatiya Nyaya Sanhita? Okay, no problem. These are the pre-law students, ma'am. Yeah. Pre-law and LLB. Okay, okay. See, as you know, from 1st July 2024, the three laws implemented or repealed by the government of India. That is Indian Penal Code, the Criminal Procedure Code, and what is another thing? Indian Evidence Act is there. So when you talk about the Indian Penal Code, so what you understood by the word code or codification, that is the most important thing. And what is the purpose behind the codification? That was the first attempt in India, that is British India, that did by Lord Macaulay, who was the father or architect of Indian Penal Code. So what you understood by the word codification? Systematic arrangement. Very good. Then she's right. Systematic arrangement. What was the purpose behind that? To arrange systematically. See, being a student of pre-law students, that's the reason I'm telling you. See, codification, what she stated that, she's absolutely right. Codification is nothing but to reduce the law into writing. And obviously, to arrange that systematically. Means once we reduce into writing, in writing, that helps to maintain the uniformity. Means there is no scope to have some kind of a discrimination, and that's the reason codification is the essential part of any law, and that did first time in India in 1860. As I told you, Lord Macaulay, who drafted this Indian Penal Code in 1834, and same was passed by the British Parliament in 1860. Again, the question was raised in your mind, why this code passed by the British Parliament? As we know, India was the colony of Britishers. The Britishers ruled more than half of the world, and among that, India was one of the colony of the Britishers. And obviously, British has right to make the law, pass the law for the Indians, and that initiative taken by the Lord Macaulay, though he drafted that Indian Penal Code in 1834, and same was passed in 1860. So means codification that reduced into writing. As you know, you studied law of constitution. As we know, law of constitution is the highest law of land. Again, that law is in written form, and that is reason it is possible to maintain the supremacy of that constitution. It means the law should be in a written form. As we know, in United Kingdom, their constitution is partly written and partly unwritten, and that is reason the parliament is supreme one, but in India, the constitution is the supreme one. Why? Because that constitution is in a written form. The same way, when I talk about the Indian Penal Code, that is also in a written form. And that was written by Lord Macaulay, and same was accepted by the British Parliament in 1860. So, what was the reason behind that? As I ask you, to bring the uniformity. See, in India, when we discuss about ancient India, or prior to that, there was a Varna system. That society was divided into four Varnas. What is that? Brahman, uh, Kshatriya, Vaishya, and Shudra. One more Varna is also there, that is Ati Shudra, and their position was very much miserable. So when the time came to punish the person, obviously that punishment was deferred on the basis of Varna. If the person belongs to higher Varna, the punishment is lower punishment. If the person belongs to lower Varna, the punishment is higher punishment. Means there was a discrimination on the basis of Varna. And when Mughal came in India, that Mughals ruled this country for more than 600 years. There to observe that punishment was based on the religion. It means there was a discrimination on the basis of religion. But when British ruled this country for more than 150 years, and they decided to have a separate code. What is that? And that's the reason they took the initiative. And one more reason for this IPC was there was a mutiny in 1857. Bharataचं बंड जे झालं होतं against the Britishers. To suppress the voice of native of Indian, they decided to have a code to rule this country, and that's the reason they passed this Indian Penal Code in 1860, and that code was implemented throughout India, or that British India. And even after the independence, even after the commencement of Indian Constitution, our Constitution came into enforcement on 26 January 1950. Might be again question raised in your mind, because these laws criticized as the colonial laws. Is it correct or not? And that's the reason we decided to change or to repeal these laws. That is one of the contention on the part of government. Why we are going to repeal these laws? As they stated that these laws are the colonial laws, and we want to change these laws. One more thing, the Home Minister of our country, Mr. Amit Shah, who made a statement on the floor of Parliament that was the Indian Penal Code, Bharatiya Nyaya Sanhita, and this is the Bharatiya Nyaya Sanhita. Means they want to give the punishment, and we want to give the justice, and that's the reason we changed the title from Indian Penal Code to Bharatiya Nyaya Sanhita. That is also one of the reason or defense to repeal these three laws are there. So what I ask you, is this law even we followed after the commencement of Indian Constitution. Now, what is another criticism against this code? This code is the colonial laws or passed by the Britishers. But though that laws passed by the British Parliament, N number of laws passed by the British Parliament. Still, we are following the same laws after the commencement of Indian Constitution. So that may raise a question in your mind: why we are going to follow those laws which passed by the British Parliament? We got the independence on 15th August 1947. We have our own constitution that passed by our centralist assembly and same implemented from the 26th January 1950. Then what is the need to follow those laws? And that answer given by the framers of our constitution. They stated that though these laws passed by the British Parliament, still we are following these laws. They insert one clause, Article 13, Clause 1, Article 13, Clause 2. These are the most important clauses which mentioned under our constitution. The 13th Clause 1, which states about the pre-constitutional laws, Article 13, Clause 2, which states about the post-constitutional laws, and Article 13, Clause 3, which defines the word law. So what is the Article 13, Clause 1? We state that the laws which were passed prior to the commencement of Indian Constitution. What is stated that prior to commencement of Indian Constitution, those such laws passed prior to commencement of Indian Constitution, if such a law or any part of such a law is inconsistent, contrary to the provisions of Indian Constitution, then after that inconsistency, such laws will be declared as unconstitutional and void. Means in a single provision, they give the answer to those laws which passed by the Britishers. It means those laws are in tune with our constitution, and that is the reason we are following those laws which were passed by the British Parliament. Then another beauty of our constitution, under Article 13, Clause 2, we state that which imposes some kind of restriction, limitation on the part of power of Parliament. We know the function of Parliament to make the laws for our country, but while making such laws, Parliament cannot make any such law which violates, which abridges any one of the rights guaranteed by Part 3 of Indian Constitution, that is the fundamental rights. Otherwise, such laws will be declared as unconstitutional and void. That is the provision which made under Article 13, Clause 2. And so, we are following that law, that is Sanhita, Indian Penal Code. So, my dear friends, it is not so easy to follow, to write down the Sanhita for any country, but that task fulfilled by Lord Macaulay. And that is the reason what I feel the credit goes to British. It's my own observation to establish the uniform criminal justice system in India. That credit goes to the Britishers. It means any offense committed by a person, irrespective of the caste, religion, status of the person, or sex of the person, the punishment is the same that defines under the IPC. And that punishment implemented from 1860 onwards till today. You might be surprised, though that act passed by the British Parliament in 1860, till 2024, there was list amendment took place under these codes, IPC, CRPC, or the Evidence Act is there. This means how smartly those codes drafted by that Lord Macaulay means list amendment. Even though in our Indian Constitution more than 110 amendments took place. No, that is one of the feature of our Constitution. It is not so rigid. It is a blend of rigidity and flexibility. It means what I intend to tell you. That was the great code, this nice code passed by the British Parliament. But one thing is certain, the change is the rule of nature. And we have to change accordingly to fulfill the needs of our society. So ultimately, our government feels that it is the time to repeal those acts. But they did some blunders while repealing or while amending these codes, as the Madras High Court criticized to repeal these codes or these laws are there. Madras High Court stated that instead of repeal entire law, it might be better to change wherever changes are essential one. Up to that extent, if the parliament did, that might be more good than to repeal the entire act. Or might be, as we observe, that provisions are clubbed together. That's the only thing. And whenever some changes, they deleted or they added, some changes are there. I will throw some light on that. And at the same time, the judge of Madras High Court also criticized to utter the word Bharatiya Nyaya Sanhita. He stated that the title of any law should be in English, not in the Sanskrit. That is also one of the things which is contrary to the provisions of our constitution. Bharatiya Nyaya Sanhita and Indian Penal Code is there. If you observe any title of law, that is in the English, not in the Sanskrit law. So these were the criticism made by the Madras High Court and the judges of High Court. And another important thing, while repealing these code, this task assigned to one professor, Professor Ranbir Singh, who was the former Vice Chancellor, National Law University, Delhi. So what I feel, instead to assign such a task, it might be more better if this task assigned to Law Commission of India and not any retired professor. But instead to that report to Law Commission of India, it refers to a retired professor, Professor Ranbir Singh. Another important thing, there was no discussion on the floor of Parliament when this bill brought on the floor of Parliament to have to suggest any changes by the members of Parliament. But at the outside, first time in the history of India, 146 members of Parliament expelled from the House, and subsequently this bill passed on the floor of Parliament. This is another blunder of this bill, because this is the major decision they are going to take by government of India. And that's the reason this bill should pass unanimously and not by with the difference of opinion. It might be more better to take some kind of how to say that their opinion, their suggestion, and if they pass unanimously, then that might be more better. But instead of that, 146 members of Parliament expelled from the House. At the outside, this bill should send to the Select Committee for more discussion. So this is not done, and these bills passed and implemented on 1st July 2024. As I hope you understood the background of this Indian Penal Code or the Bharatiya Nyaya Sanhita. When we talk about the Indian Penal Code, there were total 511 sections, and same sections were divided among 23 chapters, which includes the definition and different kind of offenses are there. They prescribe the punishment for those offenses are there. And that is a limitation on the part of judges not to impose more punishment than the punishment which prescribed under the IPC is there. So that is the first time done in the history of India in the form of Indian Penal Code. It means there was no discrimination. Suppose the offense of theft. If that offense of theft committed by you people, myself or any other person, the punishment is same. That punishment was given as a 3 years imprisonment. Means it is the discretion of that competent code to impose 3 months, 3 days, might be 1.5 years, but not more than 3 years. That is the upper limit to prescribe the punishment. In that way, such kind of work did by the Britishers first time in India. But in independent India, that government of India decided to repeal or to change these acts, and by way, these 511 sections reduced into 358 sections among the 20 chapters. Initially 511 sections, 23 chapters, and now 358 sections, 20 chapters are there. 19 sections are offenses are added, 31 offenses are to be deleted, 19 new offenses added under the Bharatiya Nyaya Sanhita, 31 offenses deleted. In 41 offenses, punishment is enhanced. Whatever the existing punishment, that punishment enhanced, and at the same time, the amount of fine enhanced from 10 lakh to 1 crore rupees under the Bharatiya Nyaya Sanhita. Otherwise, there was a meager fine, but now the maximum fine is 1 crore rupees under the Bharatiya Nyaya Sanhita. I'm going to talk about the punishment. See, some punishment prescribed under the IPC, and there is no other punishment other than that punishment. You might be studied under the criminology and penology. Might be flogging, oiling, beheading, stoning. Such kind of punishments are not prevail in India. So initially there were only 5 punishments: death sentence or capital punishment, life imprisonment, imprisonment either simple or rigorous imprisonment, fine, and forfeiture of property. And now they decided to add one more punishment in the form of community service. So what is that community service? That is not prescribed under the Bharatiya Nyaya Sanhita. Prior to this, that punishment prevails under the Juvenile Justice Care and Protection Amendment Act 2015. That was the only act which prescribed about the community service. But what I feel, this is the welcome step on the part of government to insert such kind of punishment under the Bharatiya Nyaya Sanhita. But what is the, they don't define it. What kind of community service is there? You might be known that the community service means the court may ask you to serve for the common man. Might be in a temple, gurudwara, or masjid. So the person may go there and have they tender some kind of services are to be there. That is the nature of a community service, and this is service. The punishment is added under the Bharatiya Nyaya Sanhita. It means under the Bharatiya Nyaya Sanhita, now there are the 6 type of punishments. Initially, death sentence or capital punishment, life imprisonment, imprisonment either simple or rigorous, fine, forfeiture of property, and along with the community services also there. At the same time, as I told you, they added new offenses under the Bharatiya Nyaya Sanhita, like organized crime, then lynching, act of terrorists. These are the new offenses added under the IPC. But when you talk about the terrorist or organized offenses, what I feel in our country, there are special laws to deal such kind of matters. When you talk about the terrorists, the Unlawful Prevention Activities Act is there. For organized crime or syndicate crimes, the Mokoka is there in Maharashtra. And what I feel, the different state having different laws to deal with the organized crime or the syndicate crimes. It means the crime committed by more than one person, Sangatit Gunigari. But even though that is the part and parcel of Bharatiya Nyaya Sanhita, at the same time lynching, as you know, the incidents that took place in our country, mere on the basis of doubt or suspicion, the person are to be killed or lynched by the mob. And this is very heinous and not good thing for the healthy society. That offense is also added under the Bharatiya Nyaya Sanhita in the form of lynching, and that lynching club with the unlawful assembly. Again, the question raised in your mind, what is this unlawful assembly? Initially, under the IPC, the three offenses defined under the offenses against the public tranquility. That unlawful assembly, five or more than five persons. Then riot, you know that, and affray. That affray means to disturb the public place. So public place, that is the affray. So this lynching clubbed together with the unlawful assembly, and that is a new offense which mentioned under the Bharatiya Nyaya Sanhita. Then another important thing is that they club some inchoate crimes together. Inchoate crimes, that is the abatement, conspiracy, and another is the attempt. As attempt is also one of the crime. Means, as you are a student of law, so you should know there are the four stages of crime. Four stages of crime. What is first thing? Intention. What is second thing? Preparation. What is third thing? Attain. Now what is last? Commission of a crime. Intention, that is beginning of that crime. That crime generates in the mind of a person. It's a blameworthy mind. But it is not so easy to read what is going on in the mind of a person. Means that is the intention, which is the most important aspect. But only intention is not punishable unless and until that club is an act is there. Means mens rea plus actus rea. What is second thing? Preparation. Generally, preparation is not punishable in the eye of law, except a few offenses are there. But attempt is always punishable. What is that? An attempt? An act which leads toward the commission of a crime, which are the means and measure leads to commission of a crime, but some unforeseen act. The act which is not in the control of a person, and so that person failed to complete that crime. So that is an attempt, but that attempt is liable to punish. And once that person succeeds in his attempt or her attempt, that turns to the commission of a crime. That is the injured crimes we mentioned earlier under 511 section. That is the last section of the Indian Penal Code. Then another is the abatement and conspiracy. As you know, abatement is an independent offense. Instigation, abatement. The three ingredients of abatement. Intentional, I am telling you the difference between abatement and conspiracy. You see, abatement, the three ingredients: instigation, conspiracy, intentional aid or omission. As we know, instigation. Suppose the A person instigates B to commit the murder of C. As I give the one illustration, A instigates B to murder the C, but B refused to murder the C. Whether A is liable for punishment? Yes, he is liable. Irrespective of the result, that A is liable to punish. And what is another thing? A conspiracy. So, though conspiracy is one of the ingredients which is mentioned under the offense of abatement, please try to give your attention. But in spite of such a thing, the legislature took a decision to have a separate offense in the form of conspiracy, and which is inserted via Criminal Law Amendment Act 1893. I'm not wrong. My friends are here. So that conspiracy is different, and the conspiracy which is mentioned under the abatement, that conspiracy is different. It means the conspiracy which is mentioned under the offense of abatement, that needs some kind of an overt act, then and then only that person is liable to punish. So what is the conspiracy? Obviously, more than one person is required to have a conspiracy. Cut. Two or more than two persons agree to do an illegal act or an act which is legal by illegal means. Such an agreement is designated as a criminal conspiracy. But when you talk about the conspiracy under the head of abatement, we state that some overt act is essential one. So myself, my answer ma'am is there. Dongra ma'am is here, Sheikh ma'am is here, and we conspired to some act, no doubt an illegal act. But unless and until we did something in furtherance of that conspiracy, till that moment we are not liable. That is the offense under the abetting. It right understood. But under the head of conspiracy, whether you did something in furtherance of that act or not, that thing is immaterial, and we are liable to punish. That is the offense of conspiracy. Means meeting of minds, that is the gist of conspiracy. That agreement is sufficient to punish the wrongdoer. Now, why they decided to insert such kind of offenses? Only two sections: the offense of conspiracy and punishment for conspiracy. And for the punishment of conspiracy, there is a provision of death sentence. Death sentence, whether you did something or not, whether there was an overt act or not, or whether you did something in furtherance of criminal act or not, that thing is totally immaterial and persons are liable to punish. Here I like to share one example of under Indian criminal justice system, how this provision is implemented and the consequence of this conspiracy. What I told you, the two or more than two persons agree to do an illegal act or an act which is legal by illegal means. Such an agreement is designated as a criminal conspiracy. Such agreement is sufficient. Meeting of minds are sufficient. It means, suppose the act which is legal by illegal means. As we know, this is usual practice in our country. Even though we have the legal word, but we have to give. That's the conspiracy. Got it? That is the reason. Legal but by illegal means. Such an agreement is designated as a criminal conspiracy. As we know, our late Prime Minister, Mrs. Indira Gandhi, who was assassinated by her own bodyguard, Beth Singh and Satwan Singh, and was later on punished as a death sentence. But there was one more accused in the form of Kehar Singh. Whether he was involved or not, still that is a question of doubt or question of debate. But what happened? The wives of Satwan Singh and Beth Singh and the wife of Kehar Singh traveled in one compartment of the railway from Amritsar to Delhi. From Amritsar to Delhi. On that basis, that Kehar Singh was prosecuted as one of the accused to murder or to assassinate the late Prime Minister Indira Gandhi. And later on, that person was punished, and that punishment was the death sentence. Again, he was prosecuted under the offense of conspiracy. Right on. Conspiracy. That meeting of minds or an agreement. When after the punishment, the relatives of the Kehar Singh tender several mercy petitions to the President of India. As you know, it is the power of President under Article 72 to have reduced that punishment from death sentence to a capital punishment. But every time that mercy petition turned down by the President of India, and ultimately he was hanged till a death. And that time, Minu Masani, who was one of the member of drafting committee, draft the Indian Constitution, and who criticized this judgment, who stated that mere on the basis of such evidence, an animal cannot punish. How can a human being punish that to a death sentence? And it is a judicial murder. That judiciary murder one person on the basis of such kind of evidence. Means there might be chances of such kind of injustice in the name of such a conspiracy. What is it that? Means agreement that is sufficient. But that is the need of our country. Because we cannot wait that person will commit the offense and then we may arrest him and prosecute that person. That is the need of our country, need of an hour to tackle the terrorist activities are here. And that reason that act was, that provision was inserted under the Indian Penal Code. Still, that is one of the provision. And at the same time, the offences against woman and child, again that clubbed together under one chapter under the Bharatiya Nyaya Sanhita. As you know, these women and children are the vulnerable section of our society, weaker section of our society. And even Indian Constitution confer some special rights on the part of state to have special provision in favor of woman and child. That is Article 15 Clause 3, which is the most important provision under Indian Constitution. And that reason, there are special laws in favor of woman, special laws in favor of child. Is it correct or not? And those offenses clubbed together under the Bharatiya Nyaya Sanhita. And now, one more important thing did by the government of India. While defining the child, they define any child irrespective of the sex, whether that child is a male child or a female child. Below 18 years, that is the child. Same thing about the gender. That gender is not restricted to the male and female gender. That includes the transgender also. It is a welcome step on the part of the government to make that changes. And accordingly, they did such a changes under the Bharatiya Nyaya Sanhita. Again, for the offense of rape, which is the most heinous offense, for which there are tremendous changes took place under the Bharatiya Nyaya Sanhita. Initially, this offense was restricted to penile vaginal penetration. Try to understand. What is that? And only man is liable to punish for the offense of rape. Still today, this offense is a gender specific offense. Try to understand. What is that? This is the gender specific offense. It means only men are liable to punish for the offense of rape, and woman is not liable to punish. At the most, woman is liable to punish for the abatement of rape, but not for the offense of rape. So this is one thing. And another important thing. What is that? A man having a sexual intercourse. It means the penile vaginal penetration. But now that made some changes. They stated that it is not restricted to penile vaginal penetration, even though insertion of finger, any foreign object into the private part of a woman that act also amount to offense of rape. It means it's a digital rape. And they enhance the ambiguity scope of definition of rape under that particular provision. It is also one of the important. And at the same time, the section 377, that section was deleted by our government. That is the Unnatural Sexual Offences Act. It means the carnal intercourse against the order of nature. That was the offense. But nowadays, that is not the offense. It is a sexual orientation that depends on the part of person. So that may not be within the purview of a criminal. What is that? The lesbian relations, gay relations. These acts are no more an offenses after it is already decided in Nautil Singh Johar versus Union of India by the Supreme Court. But Supreme Court partially decriminalized that section 377. And the Supreme Court stated that the relationship between two consenting adults in a private, then no one can peep into that affairs. So that may be their personal affair, and those persons are exempted from the criminal liability. But this is an offense against the child and without the consent of a person. If person having such kind of relationship might be sodomy or bestiality. But nowadays, this is no more an offense that is clearly deleted from the Bharatiya Nyaya Sanhita. That is one more change. And as I told you, for this offense of rape, initially the minimum punishment was 7 years and a maximum life imprisonment. As you know, after Nirvaya, a lot of changes took place. But now, the minimum punishment is 10 years and maximum punishment is the death sentence. As you know, Nirvaya case, persistent vegetative state. Again, it defines under the age of 12 years, under the age of 16 years. If the same offense committed by repeated offense, again there is a provision of a death sentence is there. So such kind of changes took place under the Bharatiya Nyaya Sanhita. Again, I like to invite the attention of my dear students. See, after Nirvaya case, as you know, a girl raped in a moving bus. And subsequently what happened, all you know. And that people enters on the road and there was chaos to tackle, to deal with such kind of offenses. Right now, Badlapur case is there in Maharashtra. So subsequently government took a decision to appoint a committee. That committee may suggest some kind of changes. And the committee was appointed under the head of Justice J.S. Verma committee. And that committee gives their recommendation, their report to the government of India. The first recommendation, to replace the word rape by the word sexual assault. Means again, to widen the definition of that offense of rape. That should not restricted to penile vaginal penetration. And one more important thing, you might be surprised. You can't believe that. That ordinance, or on basis of recommendation, that ordinance was issued by the President of India. You know when ordinance is to be issued, and that power given to the President of India under Article 123 of Indian Constitution. Means when Parliament is not in session, if there is any kind of urgency, then President has the power to issue the ordinance, and that ordinance may act in the form of a law is there. But when that ordinance was to be issued by the government of India, you can't believe that ordinance was the gender neutral ordinance. This is most important. Means up to that extent, even that woman might be prosecuted for the offense of rape. But when time came to convert that ordinance into the act, again there was a lot of opposition on the part of women's organization. There might be more victimization on the part of women, and government didn't dare to convert that ordinance as it is. And again, the offense of rape remains as the gender specific. And still, this offense is the gender specific. Under only two exceptional cases, That offense is the gender neutral, that is vagarism. As you know, to watch the sexual acts without the consent or permission of the persons, and to disrobe a woman with intention to um, uh, violate her modesty. These are the only two provisions which are the gender neutrals are there. And otherwise, still this offense is the gender specific. But one thing is there, the ambit and scope of this offense of rape is widened much more compared to the earlier things are there. And another important thing, as I told you, about the offense of child, that they prescribe the age of child irrespective of the sex. The male child or female child below the age of 18 years. Here I like to give an example of few offenses. Kidnapping. Initially, section 359 we define the kidnapping is of two types: kidnapping from India, kidnapping from lawful guardianship, punishment for kidnapping, and abduction. The last part of my speech. So, in kidnapping from lawful guardianship, we state that the person whoever kidnaps any child, he takes or entices any child. If that child is a male child, below 16 years. If that child is a female child, below 18 years. Or person of unsound mind of any age. It means they make the discrimination on the basis of age. But now they club together all the offenses, that kidnapping of two types: kidnapping from India, kidnapping from lawful guardianship, and the child is the any child, irrespective of the sex, the child below the age of 18 years. If you want to study the kidnapping from lawful guardianship, you have to study two important case laws: Vadagama versus state of Gujarat and Varadarajan versus state of Madras. These are two important landmark cases to study the kidnapping from lawful guardianship is there. It means some changes are very good changes did by the government of India while repealing, while changing these three major laws which we followed from 1860 to 2024 is there. One more thing. In the year 2000, another committee was also appointed under the chairmanship of Justice Mallimat Committee. That is the 11 or 12 members committee, and that committee asked to suggest some kind of reforms under the existing criminal justice system. But even that committee also could not dare to touch to the substantive law. They made some kind of change under the procedural law, but not to the IPC. Means this was not the first attempt to change, to repeal these laws are to be there. But now, right now, they decided to change this law, this to repeal these laws are there. One more thing, these changes gives much power, lot of powers to the police authorities, irrespective of their position. That is another blunder of this IPC or the Bharatiya Nyaya Sanhita. It means the purpose of our constitution to establish the social welfare state. For some time, the fear raised in my mind whether that leads toward the police state. That gives such kind of enormous power to the police. So at last, I like to say, no doubt changes are essential. We have to change according to the needs of our society, but not up to this extent. And I agree with the opinion expressed by the Madras High Court. Except means those changes, there was no need to repeal all these three laws are to be there. But now we have to accept these changes, and accordingly we have to uh, follow these changes are to be there. I hope you understood about this Indian Penal Code or Bharatiya Nyaya Sanhita. And at last, I express my sincere thanks to Ansari ma'am, her colleague, for inviting me and having such kind of discussion with the students of this MGM universities there. Thank you. Thanks.
Thank you so much, sir, for sharing with us insights of criminal law. It was a wonderful and enriching session. I'm sure students have got an idea about the changes made in criminal law, that is Bharatiya Nyaya Sanhita 2023, and definitely be benefited out of it. If anyone wants to ask any questions, they are free to ask. Students, if you have any questions, you are free to ask, sir. No one?
So can you elaborate more on the Madras High Court
their opinion. And one of the judge also stated that I am not going to use the word Bharatiya Nyaya Sanhita. In future also, I will utter the word Indian Penal Code. That is the only thing. No, 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 no. See, there is no question of the sections. Initially, there were 511 sections. Now, those clubbed together under the 358 sections. As I told you, see the kidnapping. The initially lot of sections are there. Kidnapping is of two types, 359. Kidnapping from India, kidnapping from lawful guardianship. Now, all the three clubbed under one section. That is the only thing. Yeah. Yes, yes. Ha, very good question. Yeah. See, marital rape only under two circumstances. That is an offense under the Bharatiya Nyaya Sanhita. Suppose during the period of judicial separation or divorce, if that husband has such kind of act of sexual intercourse, then that person is liable to punish. Initially, that punishment was 2 years. Now, I think that may extended for the period of 5 years. One more change. By the consent obtained by the deceitful means, suppose by giving the false promise of marriage, if that person develops such kind of relationship, initially there was a difference of opinion on the part of different high courts of our country. Some of the high courts stated that it is the offense of cheating, but not the offense of rape, because there was a consent on the part of prosecutors. Though that consent obtained by way of false of marriage. But right now they specifically mention by way of deceitful means, and those persons are liable, and their punishment is up to 10 years. What it, and that marital rape is restricted only two things, or the separation by of custom or traditions, or 1 day or 2 days. And even that during those period, if that husband having a sexual intercourse, then that person is liable to punish. But apart from this thing, there is no question of the marital rape. It is presumed that that husband has right to have a relation with his wife. There is no question of the consent, though that consent is the gist of offense of rape.
So while you were talking about that, it may be like converting to a police state.
Yeah,
So
yeah.
there are some familiar like earlier there was only 15-day custody, now it's 90 days custody, and anymore means such
Yeah,
laws like
because why I use this word?
against the state laws means.
Yeah, yeah, because right now these laws gives more power to police authorities. See, and again, who is that police? Whether that is Zamadar, Constable, PSI, DOS, PSP, that is not mentioned under these things.
So anymore like you want to elaborate anymore things like offenses against state and all.
No, no, no. One thing again. Initially, one of our section 124E is there, sedition. In number of cases, Supreme Court stated that it is time to repeal that sedition. What the government did, instead of sedition, they brought treason. It means राजद्रोह की जगह पे देशद्रोह लेके आए. Only they changed the word from sedition to treason. Again, maximum punishment is to be there. It means what was the intention on the part of Britishers in the form of sedition? To suppress the voice of natives of India. If they raise their voice, the place will be behind the bar. But now our country is an independent country, and native of Indians has right to raise their voice, to ask the questions to the government about the policies, and just to suppress with the same intention, the intention which having on the part of Britishers, they replace the word sedition with the word treason. It makes no difference.
There are no difference against the law.
Obviously, no. That's the reason that opinion expressed by the Madras High Court.
Good afternoon, sir. So you told there is conspiracy in abatement and criminal conspiracy. So can you please elaborate on what's the difference between the?
That's what I told you. Under section 128, initially word, what is it? The mere agreement, that is sufficient. Means no need to prove any other things. Means whether you did something in furtherance of that agreement, that is immaterial to fix the criminal liability under the head of criminal conspiracy. But when you talk about the abatement, we have to take some kind of initiative. What we decided, what we conspired. Till that moment, that persons are not liable to punish.
So, what is a overt act? I mean, you
see,
overt act
suppose some of the terrorist persons come together and they want to do some kind of bomb blast or something else, and just for that purpose, they are preparing or they conspire that meeting is sufficient to punish those wrongs. Means no need to wait unless until they did something and then we may arrest and prosecute them. Means prevention is better than cure. That is the theory.
Thank you, sir.
Very good, nice question. See, you are just a pre-law second year students. As we have experience, my colleagues are here. There is no difference between the capital punishment and death sentence. Synonymous words are. Yeah. Anything else? Good. Well, thank you.
Uh, so I would like to know one personal opinion of yours about the changes made in IPC, that is in Bharatiya Nyaya Sanhita. So I would like to ask that earlier, whatever laws we are having, as you said, that no uh, ma- uh, new changes, not as such great changes have been made in the laws. So I would like to ask for the students who have studied for 7 to 8 years the sections, and now the sections has been changed. So is it not difficult for them to again learn the new sections?
Obviously, difficult as well. I mean, initially, even common man also knows 302 it's murder, 376 it's offense of rape, 378 it's offense of theft. But nowadays, again, they have to change. So this is also one major difficulty. That's the reason that Madras High Court said that no need repeal the entire code. Wherever changes are essential, if we made that changes, that may fulfill
Yes, we
the
could have just kept the
Exactly.
laws as it is,
As
and
it
whatever
is.
the sections which were repealed, we could have just repealed them
That is the
and
only.
kept the act as it is
As it
intact,
is.
right?
Yeah,
So,
yeah. What I feel that might be more better. That's the reason I agree with the opinion of Madras High Court.
so this question is as a student, sir, to you as a professor, that how students who have learned the sections earlier, how to learn the new sections again.
See, right now, we don't have an option. So again, we have to start from fresh. We people also teach to the students, and students also. Means what I feel it is more difficult for we people than students. Because from long back, from last 20 years, we are teaching the same sections and we are more acquainted with those sections. Section 96 to 106, yes, the offenses, the general exceptions are there. 76 to 106 is there. Right of private defense. But now we have to change. Even it is difficult for me also while teaching the students. Means we don't have an option, man. We have to.
Okay, sir. Thank you so much, sir. I extend my heartiest thanks for accepting the invitation and gracing us with your knowledge, sir. Thank you so much. Now we'll have a lunch break, so all the students are requested who have registered.
Question.
You have a question?
Yes. सर आपली न्यायप्रणाली खूप स्ट्रॉंग आहे सर. तरी पण आरोपीला म्हणजे त्याचा आरोप सिद्ध व्हायला खूप वेळ लागतो सर. तर असं का सर? प्रोसेस खूप जास्त लागते सर.
नाही कसं आहे presumption of innocence is the basic feature of our criminal justice system. What is saying that is, and it is presumed that every accused person is innocent unless and until he proved to be guilty, that to beyond all reasonable doubt. So that burden shifted on the shoulder of prosecution lawyer. It's his duty, and if they fail, obviously that person remains outside the purview of criminal law. त्याला पर्याय नाही राजा. आपली ही सिस्टमच अशी आहे की तो गुन्हा सिद्ध झालाच पाहिजे आणि तो गुन्हा जोपर्यंत सिद्ध होणार नाही तोपर्यंत तो निरपराध आहे असंच ठरवून येईल. आणि दिस बेसिक प्रिन्सिपल ऑफ स्पेसिफिकली ॲडव्हर्सरियल क्रिमिनल जस्टिस सिस्टम. आणि सरकारचा हाच विचार होता की त्यामुळे त्यांनी हे चेंजेस आणले. बघूयात आता भविष्यामध्ये काय होतं.
So, one more question I would like to ask you. As this one of my friend has asked me, he is not a law student actually, so he just questioned me. This is what he feels about our laws and our legal system, that laws are more benefited to criminals than to victim. How much true it is?
See, as I utter the word justice Mullimat committee, that committee was suggested few changes to make a balance related to the rights of accused person and the rights of victims. See, we follow the adversarial criminal justice system, and it is presumed that the system is accused oriented and where victims of crimes are neglected object and subject. So to uplift the status of that victim, they made some kind of changes. Right now, victim has more rights under our criminal justice system. The same rights he enjoy under the inquisitory criminal justice system.
But sir, whether it is an implementation
Yeah,
also.
yeah. Few changes under the CRPC, even under the evidence is also there. Even right now, victims of crime has right to prepare an appeal. Even he has right to engage a lawyer also. Means to have more participation. No doubt, it needs more efforts on the part of government to make a balance. On one hand, rights of accused. On another hand, rights of victims are to be there. But that process is already initiated on the part of government of India.
Okay. Thank you, sir. Sir, we would like you to offer the lunch after this session. So all the participants are requested near the CGMC. We have arrangement for the lunch. You can have your lunch there, and we'll be back in 45 minutes. We're going to start with the second sessions.
Thank you, ma'am. आणि मला असं वाटतं की you have to arrange such kind of symposium to have more discussion. Thank you. Thank you. Hearty congratulations.